if you flip on TV right now and turn on Law and Order or some other criminal justice show, it is very likely that you will hear them discussing, at least in some form, this concept of plea bargaining. So what exactly is a plea bargain? Well, a plea bargain is an agreement made between the defendant and the prosecutor, whereby the defendant agrees to plead guilty to a specific charge in exchange for some sort of concession from the prosecutor. Okay, this is usually done by reducing the number of charges against the defendant or lessening the severity. So instead of charging them with first-degree murder, they'll get charged with second-degree murder. Or instead of possession with the intent to distribute, they'll just be possession of large quantities of a substance. This is critical because this lessens the burden on the criminal justice system, in particular in the courts, right? It allows the prosecutors to focus their time and resources on other cases while also lessening the number of trials that require the supervision of a judge. What's more, however, is that not all plea bargains are just this agreement to plead guilty. Sometimes they require that the defendant testify against other defendants for the state. So how might plea bargaining have victims? We're going to watch a brief little video here, and as you do, I want you to be thinking about who exactly benefits from plea bargains, and who, if anybody, loses. Are there certain types of people that are more likely to benefit from plea bargaining? Or, in contrast, are there certain types of people that are more likely to be harmed by plea bargains? Right? And who is impacted by the plea? Because it's more than just the offender. So, we have this idea that court and having a jury trial is a fundamental right, and it is. However, about less than 3% of all state and federal cases actually go to trial. In other words, 97% are resolved with a plea bargain. So there's three types of plea bargainings, or really there's three places in the process that bargaining can occur. So the first is it can be a charge bargain, so that you can be bargaining about the severity of the charge, right? So as I already mentioned, going from first degree to second degree murder. Okay, then there's also count bargaining. So let's say I've been charged with, 17 counts of possession of illegal firearm. Okay, what part of my bargaining tool would be, okay, well, instead of 17, maybe we could do 2 or something, something else along those lines. Okay, and then finally, sentence bargaining refers to an agreement made that I will plead guilty knowing the sentence I'm going to get. And this, as we see, is quite common. Okay, people are very nervous about the unknown. If you have 25 years dangling in front of your face and the prosecutor says, well, sure, yeah, you could go to court if you want. You could take it to the jury. But if they find you guilty, you get in 25 years. Or you could take this plea and serve 2. You're going to be hard-pressed to find someone that's not going to at least seriously consider taking the 2, even if completely innocent. So this video is a good little background on it, so hopefully this will help you all a bit.
Plea bargaining is the process by which a criminal defendant charged with a crime, or multiple crimes, agrees to waive his or her constitutional right to a jury trial.
A criminal defendant is given an opportunity to plead guilty to a lesser charge in exchange for the prosecutor not bringing the higher charge. So a person who is charged perhaps with murder might plead down to a manslaughter charge instead. In exchange for that, the prosecutor chooses not to hold a full trial.
The public has this image of jury trials as making a bulk of our criminal adjudications based on what they see in TV and in movies, and that is a vanishingly small part of our criminal justice system. This is a relatively recent process. This was absolutely unknown at the time of the founding. The Constitution makes no mention of plea bargaining whatsoever. The presumption, both historically and in the text of our Constitution, is that all criminal trials would be by juries.
In the early period of American history, the right to a jury trial was not really considered as belonging to the criminal defendant. Essentially, it was a right that the public enjoyed, not the defendant. And as a result, criminal defendants were held to be not allowed to waive their right to a jury trial. That began to change in about the 1870s.
It primarily arose because the criminal justice system simply was unable to process all of the criminal charges that the government was bringing through the relatively more extensive, time-consuming process of the jury trial. Today, plea bargaining, rather than the jury trial, makes up the bulk of our criminal justice system. 97% of all federal convictions today are obtained through plea bargaining, not through jury trials.
The principle behind plea bargaining, then, is that the right to a trial belongs to the criminal defendant, just like a piece of property does, and that, in essence, the defendant can sell the jury trial right to the prosecutor in exchange for a lower charge.
I think where we are today is that this really can't be called a voluntary process, because you have criminal defendants who are being threatened with 20, 30, 40 years in prison. Who would possibly risk that when you could walk away with 2 years in prison?
One of the benefits to the plea bargaining system to the criminal defendant is that it allows the criminal defendant to get on with their life by accepting guilt for a lower offense without having to go through the complicated, expensive, and time-consuming process, and humiliating process, of a trial in front of a jury. If a criminal defendant is willing to give up that right in exchange for a lower sentence, then society should be okay with that. That also saves taxpayers money and relieves the system of a burden that might otherwise make it difficult to keep the society safe. It allows prosecutors to concentrate their efforts on high-level offenders and bring those to trial without having to bring every case to trial that involves a relatively minor offense.
There's a separate set of issues in terms of how you encourage certain defendants to testify against others. And in principle, you can certainly appreciate, the goal of wanting to encourage certain members of a criminal organization to give honest testimony against others. But in practice, what you see happening is the prosecutor essentially coercing defendants into giving testimony that the prosecutors want, whether it's true or not. On the whole, the Supreme Court has been perfectly willing to bless plea bargains. And you can understand why it's a difficult concept for the court to address, because exactly where the line is between coercive and voluntary pleas is a difficult question in principle.
So you'll have access to that video through the PowerPoint slides that are available to you. I urge you to rewatch this. It will be useful in helping you with the quiz that will follow this video. Okay, so one of the things that I've done in the past for an assignment and that you will be doing so you can begin to think about is I have assigned students to make memes. And that was an assignment I used in the past, and I'm going to use it again. So you guys can start thinking about this, in particular in the context of victims of the criminal justice system. So this is one that a student made, right? This idea that here you are, your original sentence is not looking so great when you got that awesome plea bargain to the side. Okay, here's another one. When a murderer gets less time in prison by admitting they committed murder, right? That's the essence of it, right? By admitting you did it, you are getting a lighter sentence. And sometimes taking a plea bargain is worse. Now, why could that be? Brew on that and see what you can come up with, okay? I don't expect you to have a completely right answer, but I certainly encourage you to try. And I look forward to seeing what you come up with. But before you do, we have one more thing to cover in this video, okay? We're going to discuss here disproportionate minority contact. This is also known as DMC, and that is what I'm going to say because it is a lot less of a mouthful. I alluded to this in our online class on Monday, but disproportionate minority contact refers to the fact that racial minorities are more likely to have contact with the criminal justice system at every step of the process. That is, they're more likely to be stopped, searched, arrested, charged, convicted, given a long sentence, and denied parole. In other words, they experience essentially a snowballing effect in the criminal justice system, right? And what results is a higher concentration of racial minorities in our prison population. Originally, this concept was developed to describe a phenomenon that was being observed among juveniles, but it holds true regardless of age. Okay, majority of adult inmates and those that are under community supervision are racial minorities. This is also true when we look at juvenile referrals to the Department of Juvenile Justice, as well as juvenile waivers. Juvenile waivers are essentially a waiver, right, that moves a juvenile out of DJJ and into adult court. And we see this is considerably more likely to occur for racial minorities. So this occurs when the proportion of minority passing through the juvenile justice system is greater than that of the general population. So if you were to look at, let's say, African Americans make up 10%. They don't, they make up 14%, but pretend they made up 10% just because it's easier. Then you would expect that 10% of the juveniles in the juvenile justice system would also be, black. However, we see that this number is significantly larger than this, and it's considerably disproportionate. So the question is it differential involvement? That is, are racial minorities more likely to have contact with the system because they're more involved in crime? Or is it differential selection, which is they are targeted more so by the criminal justice system, by law enforcement, and that is what makes them become overrepresented in the prison population. So the Juvenile Justice and Delinquency Prevention Act of 1988 was the first that really required states to start recognizing and combating what they initially saw as labeled disproportionate minority confinement, because they saw they had so many racial minorities in these juvenile facilities. 14 years later, they expanded that confinement to contact. And since that time, it has now been expanded to describe adults as well. So there's some problem, as you might imagine, some concerning issues that stem from disproportionate minority contact. Okay, not surprisingly, this is a huge influence upon the likelihood of people to call the police when they're in a problem, when they have a problem, right? They don't trust the police. They feel targeted. They feel as though they have, a target on their back and that the police are out to get them because they see so many people they know that look like them being under the watchful eye of the criminal justice system. Right, this has helped breed this mistrust of the criminal justice system and law enforcement in particular, right? And going even further, it's bred a lack of trust in the educational system. If you recall the Kapler and Potter reading, right, the school to prison pipeline, where we see juveniles being shifted over to the criminal justice system rather than being handled within the school, right? Their involvement now in the juvenile justice system has grown. And as a result, many people in these communities no longer trust the school system either. So this has really helped feed and fuel the fire of divisiveness that exists between the community and law enforcement and the law in general. Okay, and in particular in racial minority areas, right? And as I've already alluded to, we have a disproportionately racial minority prison population that is inconsistent with what we see in terms of rates of crime. So if you're sitting there thinking, well, yes, they commit so much more crime, unfortunately, that it just doesn't add up. Especially when we look at drugs, right? Drugs don't really. Let me rephrase that. Addiction doesn't really see race. It doesn't matter. It affects everyone, and the rates of usage, rates of addiction are relatively consistent across races, in general, for just talking about drug use in general. But yet, racial minorities are consistently more likely to be arrested for both possession as well as selling and manufacturing of any sort of illegal substance than are a white person. Now, with all this said, I want you to brew on how disproportionate minority contact and plea bargaining could possibly be related to victimization, and then move on and complete the questionnaire that is to follow, and we will pick up with racial profiling once you have completed that.